Good morning, all. Okay, this is the second segment in our program today. The first one focused on self-care and being good friends to our colleagues in the profession so that when they're showing signs of distress and showing signs that indicate that they need assistance, that we're there for them. This section of the panel looks at the practice of law through a slightly different filter. And what we're going to look at in this panel is how we deal with the clients who come before the court who have mental impairments. Now keep in mind, under Virginia Code, I teach Virginia Civ Pro, so I get to say this. There's a specific section of the code that says if a person is under a disability, if that person is engaged in a case, that a judge has an obligation to appoint an attorney for that person unless they already have an attorney. But I think the real quandary is, how do we identify the folks who have mental impairments who in fact are in need of this assistance? I was a legal aid attorney for many years, and I would say probably 20% of my caseload were clients who had both physical and mental disabilities. I now direct our clinic here at the law school, and I would say probably about 20% of our clients in the clinic suffer from mental disabilities. When you take your CLE as an attorney, they tell you how to identify the marks of the troublesome client that you don't want to take on. But I'm not aware of any CLE that tells you what markers to look for that may tell you that your client is mentally impaired and that you're going to have to approach that client differently in order to establish communication and in order to establish credibility with that client. And yet, for those of you who are law students who are navigating first and second year, and whose initial experience with law school was it's almost like learning a foreign language, imagine trying to navigate the legal system without the advantage of some legal training, without an understanding of what the roadmap is and how to make your way through it, and how to do that without the assistance of an attorney. And so that's the issue that our panel is going to speak to today. And I have to tell you that this is a collection of experience and talent that when we have space between presentations, please take advantage of it and talk to these people, because they will give you insights that you will never garner from the case books that you're reading in class. I'll introduce you briefly to our speakers and in the order in which they will present, and then I will basically turn the docket over to them. The first of our speakers, and I asked them to pronounce their names for me phonetically, the first of our speakers, although some I don't need it honest, will be Emily Hedrick, who is Ethics Counsel for Virginia State Bar. And you might not think of ethics being an issue that comes into play, but certainly being aware of whether or not a client is incapacitated and even capable of effectively participating in a proceeding is an important one. Ms. Hedrick serves as Assistant Ethics Counsel for the Virginia State Bar. She also serves as staff liaison to the Standing Committee on Legal Ethics and drafts ethics advisory opinions. Previously, before joining the bar, she was a law clerk fellow at the Supreme Court of Virginia of the chief staff attorney. So welcome. Our second presenter will be Dr. I need to find my phonetics here. Dr. Hudasek. Did I get it right? Thank you. And I think, again, one of the things she underscores for us is that working in this area and have clients who suffer these disabilities, we need to be interdisciplinary in our perspective. She is a licensed clinical psychologist. She has a doctorate in clinical psychology. She has a wide range of experience in that area, and specifically, she's the Director of Psychology and Pretrial Forensics Services at Eastern State Hospital in Williamsburg. And she also has managed a regional jail and jail-based diversion and competency restoration programs in Central Virginia. Prior to moving to Virginia, she worked in numerous governmental and academic agencies, and she has such a strong profile in community-based mental health centers. So thank you for participating in this panel today. We look forward to hearing from you. The last of our panelists are all judges, sitting judges. The first is the Honorable Jacqueline Talevi, and she is the Chief Judge of the Roanoke City General District Court. And I can tell you, as someone who's a mediator at our General District Court in Virginia Beach, that very often within the pro se litigants, I see a number of folks who have mental health issues that impair their ability to present their side of a case and to follow instructions. Judge Talevi is currently General District Court, but she's previously served in a public defender's office. She's been an adult probation and parole officer, and she's served extensively within Virginia State Bar on her education committee, criminal law section, civil law for general district courts, the professionalism court, and so we look forward to your insights today, and welcome. Our last two participants are also both judges, and they are going to collaborate in their presentation. One is Judge Migliozzi, who is currently the presiding judge for Norfolk Circuit Court. And just as an aside, I have been in his courtroom along with the advocate for a trafficking victim when he was doing handling appeals of denial of bail. I have to tell you, it's okay if you put your hands over your ears so you don't hear what I have to say about you. But I think one of the things that really impressed me about him as a judge is he explains to people what's going on and what he expects of them. And when people come in without attorneys, understanding what the court expects of them so that they can change behaviors in the future is really important. Now, a part of his portfolio is that he has presided over the mental health court for the Norfolk Circuit, and he will be sharing more of that with you today. So I hope I haven't embarrassed you, because with the clinic I may have to be in your court, so I'm going to be in good standing. But thank you for being here today. And last is John Doyle, who is also a sitting judge. I remember when you ran for Commonwealth Attorney, I saw your signs in my neighborhood. So you have some history in my neck of the woods. And again, this is, one of the things that's so interesting about the panelists today is they're interdisciplinary. And we have folks who have served as public defenders, and we have folks who've served as Commonwealth Attorney. So you're going to get the perspective of both prosecution and defense. If I recall correctly, Judge Migliozzi actually did a clerkship at St. Elizabeth's Hospital in D.C. And for those of you who are too young to remember, that's where John Hinckley, the young man who attempted to assassinate Reagan, was sent for treatment until he was recently released. So he really has a long history on this issue. Mr. Doyle comes to us with experience both in Commonwealth Attorney's Office and now as a sitting judge. We appreciate your taking time out to be with us today. Welcome. I'm going to turn it over to you.
So I'll start with just, especially for those of you who are law students, a brief overview of what I do and why I'm here. I'm assistant ethics counsel for the bar. There's 4 of us in my office, and our primary kind of public-facing activity is staffing the ethics hotline, which is a confidential, free source for ethics advice in your own pending cases. We don't offer advice about other lawyers' behavior, but any lawyer, anytime, can call or email us and get an opinion on what you should do, whether you have a conflict, how you should handle a particular situation. And that's all maintained in a confidential electronic database. So the records are available if you ever need to prove that you relied on our advice, or otherwise demonstrate that you did call us and did give us a fair and accurate representation of what was going on with your case. We also draft ethics opinions. We maintain and modify the rules of professional conduct when necessary. And just to follow up on the last panel, I actually drafted the comment to Rule 1.1 that was just adopted on Wednesday, and really had to advocate for that a lot more than I thought I was going to. I thought it was kind of a no-brainer, but I'm so happy and relieved that the Supreme Court adopted it and it's effective immediately. And I'm really glad to see this focus on wellness and well-being at every level of the profession, because it's so important. My presentation is going to start with just an overview of the rule of professional conduct that applies to representing clients with diminished capacity, which is Rule 1.14. This is not something I ever learned anything about in law school. I may not have even known it was a rule until I was already a practicing lawyer. Basically, you start off with 1.14a, which says, whenever possible, you maintain a normal attorney-client relationship with a client who has diminished capacity. Diminished capacity can mean just a client who doesn't have full legal decision-making capacity because they're a child, because they have some mental impairment. In certain situations, it can just be a client who's incarcerated. It can also mean a client who has some significant mental health issue, brain injury, drug addiction, something that actually is impairing their ability to understand and make decisions about what's going on. But you always start from the premise that you maintain a normal attorney-client relationship and maintain normal communication with them whenever possible. And then you move to Rule 1.14b, which I'll just read out loud. It says, when a lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. And the rule and comment go on to say that you can disclose confidential information even as necessary to take that protective action. So basically, you can see from the language that this is all giving a lot of discretion to the lawyer and leaving the lawyer in a position to make a lot of judgment calls. So I'll just come back and make another plug for the ethics hotline. If you're ever in a situation where you're dealing with this kind of client, you're not sure what to do, you're not sure how far to go, you can call us and talk it through, and we can at least try to give you a gut check on whether what you're thinking is reasonable or not, or whether there's some other ideas that we can offer. So again, you're not just client with diminished capacity, but the client is at risk of substantial harm because of that diminished capacity and can't adequately act in their own interests. This is all your reasonable belief about what's going on and what issues are endangered based on this. And then again, reasonably necessary protective action in your own best judgment. And a lot of that is going to depend on what you know about the client's position. Do they have mental health providers currently in place? Do they have supportive friends or family who might be able to intervene? Are they incarcerated or not? All of those things can make a big difference in terms of what protective action might be available. If there's a supportive family in the picture, it might just be a matter of calling the client's brother, mother, wife to say, hey, does he seem okay to you? Have you noticed any issues? Do you know if he's taking his medication? And that might be appropriate under the circumstances. In other circumstances, it might be an emergency situation. The client is immediately suicidal, the client is living on the streets and clearly in danger with no one else available to help. The client is involved in a major financial transaction where you question whether she has the capacity to actually make decisions. And those, you might need to jump straight to more of a restrictive protective action, up to and including considering asking for the appointment of a GAL or guardian or conservator if things have developed to the point where the client really can't make her own decisions or act in her own interests. There's an ABA opinion that really walks through all of this, particularly the situations where a guardian might be necessary or appropriate, starting from the framework that guardianship is always going to be the last resort. That's the most restrictive action you can take and the most likely to jeopardize the client's other interests in the representation. Typically, you aren't seeing these issues in a client who comes to you because they have mental illness. You're seeing these issues in a client who is facing criminal charges, who is dealing with needing a power of attorney or needing an estate plan in place, who is dealing with a financial transaction, and you start to develop concerns that they may not know what's going on. They may not fully understand what their options are. And in those situations, disclosure of the client's mental illness or other diminished capacity issue can harm the client's interests in whatever they came to you for. So you're always balancing those interests against each other and deciding when it's appropriate to intervene, even though that may come at other costs to the client. And the last comment to Rule 1.14 helpfully says, this is an unavoidably difficult situation for the lawyer. And it is. It's never going to feel good to disclose that your client needs a guardian, that your client can't make her own decisions, that you worry that your client doesn't have the legal capacity to do what she's trying to do. Even more so when that may expose the client to more restraints on their freedom than they would have if you could just handle the case on your own. This is an issue I think that comes up a lot, especially in the legal academy, in minor criminal cases where the consequences of a finding of incompetence, where the client has to be treated and attempted to be restored to competency, can result in the client being locked up for a lot longer than if they could just plead to a minor misdemeanor and probably get out with time served. The ethics authorities are pretty clear on the point that your duty to the client and your duty to the legal system are to raise the client's competence as an issue anytime that becomes an issue. The Indigent Commission Standards of Criminal Defense and the ABA Criminal Defense Standards also essentially require that in any situation where you reasonably believe that the client's competence is an issue, that you raise it to the court and have the appropriate competence evaluations done. Again, even if that seems like it may lead to a worse outcome for the client. I already mentioned the suicidal client scenario. That's one that comes up a lot in all kinds of cases. I think probably in the realm of diminished capacity issues, this is the one that we hear the most about on the hotline. The client just came to my office and said, he can't go on like this. If his wife wins this case, then he's going to kill himself. Or my client called me from jail and said that, if he gets convicted on Thursday, then he's going to kill himself. What can I do? And Rule 1.14 definitely allows you to take whatever reasonably necessary protective action you can. And again, that's going to depend on what the client's circumstances are. Clients in jail, you probably know who to call to keep an eye on them. If the client's at home, then again, it comes back to, is this a situation where you want to call family members, a doctor that you know about to check in with him, or is it a right this second emergency situation where you may want to call Adult Protective Services or law enforcement to try to immediately intervene? again, a lot of judgment calls. I think we hear from a lot of lawyers who don't really think that the client meant it as an, I am going to do this today. It's just an, I'm really upset and I hate how things are going. And you know your client better than we do. You know your client's situation better than we do. It's your judgment about whether that's a serious threat or not, and whether any protective action is actually necessary under those circumstances. I think another reason, beyond just in the criminal context, another reason why you often have to raise incompetence or potential incapacity as an issue is just part of your duty of competent representation of the client. I think this is one that comes up often in non-criminal contexts. So you have a client who wants a power of attorney prepared or wants a will prepared, and you have questions about whether she's actually competent to make that decision. Looking into whether she's competent and whether that power of attorney is going to be valid under those circumstances is a key part of providing competent representation to her in those situations. You're not doing her any favors if you don't take the steps that you can take to make sure that she can accomplish what she wants to accomplish. You don't want to be drafting a power of attorney for a client that's immediately going to be subject to challenge because she may not have had capacity to do it. So again, it comes back to the balancing of client's interests in confidentiality and in maintaining a normal attorney-client relationship versus the client's interest in having the legal services that they came to you for prepared and done competently. And I think that's another situation where things can stack up on the side of needing to disclose, where you can't just maintain a normal attorney-client relationship because it goes so directly to the key aspects of what you've been hired to do for the client. I think I'll close with a few other points about the special role that this plays in criminal cases, because I think most of the other panelists will discuss what a major issue this is in criminal cases, but it also has obvious ethical implications because due process and other constitutional guarantees have been so directly applied in the criminal case, and there's no possible argument or counterpoint to the position that your client has an interest in being competent to stand trial and in making informed, knowing, rational decisions in their case. And if there's a question about the client's ability to do that, or about whether they really understand what they're agreeing to, about whether they're making rational and stable decisions, even if they're not decisions that you agree with, even if they're not decisions that seem like good ones, lots of clients make bad choices. But if they know and understand and are able to make a stable decision, understanding their alternatives, versus having no understanding of what's going on, what their choices are, whether they have defenses available to them, etc., those don't just have competence and communication, normal attorney-client relationship implications to them. They also have constitutional due process implications. And again, I think that's recognized in the criminal defense standards and in the case law on attorneys' duties to act in that context. And I think it really takes on a very central role for lawyers representing criminal clients. And I'll end there.
Good morning, everyone. I have to stand. I feel more comfortable that way, and appreciate the opportunity to be here as one of the few mental health professionals today. I'm going to talk to you about, I want to try and give you a broader view. I'm very much a systems person, so I'm going to speak to you about how persons with mental illness end up in state hospitals and kind of the nature of the crisis of people with mental illness in jails and essentially stuck in this awful circle of arrest, jail, mental health treatment, back to jail, back into the community, and possibly with not the same, no additional supports as a result. So the concept is called essentially the criminalization of the mentally ill, and the Department of Justice estimates that at any given time there's about 16% of their population this is just jail inmates, so these aren't folks in prison, it's just pretrial, persons in jail suffer from a mental illness. And Policy Research Associates, Hank Stedman and his group estimated all the way back in 2009 about 17% and 34% for women, the difference being primarily trauma-based disorders for women being the difference between the two. Not obviously excluding that men cannot suffer from equivalent post-traumatic stress reactions. But I think the important thing that I certainly want to note is that 70% of jail inmates with mental illness are there for nonviolent offenses. And so that's not really what we hear from the media, right? We hear a lot of all these mentally ill people, or they're violent, they're creating, they're wreaking havoc in the community. But the reality is that many people with mental illness in the criminal justice system have actually been victimized. They're more likely to be victimized than to actually victimize someone else. And they're more likely to be arrested for nuisance crimes, right? Crimes of survival. So this is trespassing, petty theft, the types of crimes that I see at Eastern State every day. In 44 states, there is a jail or prison holds more persons with mental illness than that of the largest remaining state hospital. And that's from the Treatment Advocacy Center. And as I think has been stated, persons with mental illness remain in jail longer than those without. They're 4 times more likely to be incarcerated for a minor charge. And in Orange County, Florida, the average time for someone in jail is about 26 days if they're free from mental health symptoms. But if they suffer from an illness, it's looking at about 51 days. And in Rikers Island in New York, it's even worse. An average stay is 42 days for someone, say, like you and I. But if a family member with mental illness were there, they're probably looking at more than 6 months, just because of a symptom presentation. And because we have to, I'm very mindful of what happens locally. Hampton Roads Regional Jail was coined by the Daily Press as Virginia's largest psychiatric institution. The Virginia Compensation Board is a group that tracks mental illness in jail. And I just wanted to show you this slide because you can see over a period of time from 2011 to 2017, the rates of mental illness has increased in our population of jails in Virginia. And of course, as the number of persons incarcerated increase, so do the number of commitments to state hospitals. And so, again, locally, at Eastern State Hospital, which is the facility that I am the Director of Psychology and Pretrial Services, I can show you, this is just one fiscal year, but over the last 3 fiscal years, it's been pretty consistent. Now, our civil TDO rate, so these are persons just in for psychiatric emergencies. They have no criminal related problem that gives them an entree into the facility. We admitted 507. But the rest of the categories are all forensic admissions, which is more than the number of civil admissions that we admitted last year. And that trend continues, and not just Eastern State Hospital. I want to show you, in the Department of Behavioral Health, we note regions, it's called health planning regions. That's why you see HPR. And there are 7. We are in Health Planning Region 5, we being the eastern portion of the state. So we're called Region 5. And you can see we're number 1. So we have the most pretrial admissions in the state compared to other facilities. That's including the maximum security facility in the Richmond area, Central State Hospital. I was just noting to one of the judges, we are in a crisis. So those of you who want to work with this population, you are needed. Our system is broken. We are admitting people, we being state hospitals. My hospital in particular easily admits 3 to 4, sometimes 5 people for competency restoration per day. We have 300 beds at Eastern State Hospital, and we are the largest hospital in the state. So, from 1999 to 2014, there's been a 76% increase in forensics. So when I tell you about the state here in Virginia, I'm here to also tell you we are no different from other states who are grappling with the same problem. This is a nationwide problem. And the increase, so it's called the forensification of state hospitals. So historically, state hospitals have served primarily civil patients. Now we're serving primarily forensic patients, patients coming in primarily for initial competency evaluation, sanity at the time of the offense, but most certainly competency restoration. That's true across the state. That's true across the nation. Most states have a wait list. Virginia used to have a wait list. We no longer have one because the code was changed to require us to bring persons in within 10 days or less. And we are doing it. That is why we're admitting 3, 4, 5 people daily. And if one facility can't take them, another facility in the state will be required to take them. Which isn't great for family members who want to visit their loved ones if they're all over the state, but that's kind of the nature of a crisis, I suppose. Many states still do have wait lists. I was at a conference last year. California has 2,000 people on their wait list to get into a state hospital. Can you imagine 2,000 people? So we're struggling, and part of the struggle obviously relates to how people enter into the criminal justice system and then essentially enter into a state hospital. I'm going to briefly review the codes, not all the codes related to criminal law and persons with mental illness, but review some of the most important ones that get folks into state hospitals. And why is it important that we evaluate people? Well, people have a right to confront their accuser. They have a right to due process in a fair trial, obviously. We have a larger societal interest to preserve the integrity of the legal process. We want to ensure we're doing the right thing for people. We don't want to make it worse. I mean, if you're becoming a lawyer, certainly it's very similar for me wanting to be a psychologist. There's an element of us wanting to help people. Some of you may feel strongly about wanting to change the system or wanting to do something different and make a difference. Competency to stand trial is the most utilized forensic evaluation across the country. This may have even increased over time, but at the last point that I looked, it's approximately 60 to 70,000 are conducted across the nation. And about less than a third are actually found incompetent. So the majority of people are actually competent to stand trial when they're evaluated. And it's most likely when the attorneys meet with their clients and they're not making sense or they've got disorganized speech, that seems to be the symptom presentation that's most likely to get them referred for an evaluation. In Virginia, one can be sent to the state hospital for a psychiatric emergency. So that's someone who's in the jail. They're demonstrating symptoms that dangerous, kind of similar to that of someone who might be in the community. So one has to demonstrate after being evaluated by a pre-screener at the Community Service Board that because of a mental illness, that there exists a substantial likelihood that in the near future it will cause some kind of physical harm, or they will suffer in some way, and that they require treatment. And those individuals are initially held for 72 hours, then there's a hearing at the hospital to see if they require further treatment beyond that time. In terms of competency to stand trial, in Virginia our legal standard is dusky. And this means that one has to demonstrate a sufficient present ability to consult with their attorney and have a reasonable degree of rational and factual understanding. And in Virginia, we have adopted Dusky, and it is very explicit in our code. And that is what we use when we are evaluating persons for competency to stand trial. And the relevant codes, 169.1, 169.2, and 169.3, all speak to just this criminal code section of competency to stand trial. And the process is that once an evaluation order is received and sent to an outpatient evaluator, because all evaluations occur on an outpatient basis first, unless there's some indication that an individual either cannot or will not participate or more information is required, then an individual can go to the state hospital for a 30-day 30-day initial competency evaluation. Excuse me. Once an evaluation order is received, an opinion is made, certainly they're competent, they can proceed to trial, or as we know, most cases they proceed to a plea agreement. If one is incompetent to stand trial, one can receive services via an order from the judge on an outpatient basis. That means the Community Service Board, that's our local community mental health centers, can provide competency restoration, kind of factual and rational based psychoeducational sessions, and also medication if needed, or on an inpatient basis at a designated department DBHDS facility. So as noted, 169.1 speaks to whether restoration can occur, where it can occur. 169.2 also speaks to this idea of we need to bring people in within 10 days. And I also kind of want to make you aware that we need to be thoughtful about how we utilize our resources. Some folks will not benefit from an inpatient stay, and I'm going to tell you those folks in just a second. And then the other code relevant is 169.3, which essentially provides for a disposition of someone found unrestorably incompetent to stand trial. So we want to think about people who are most or better suited. Of course, it's the judge's decision, of course, but from a clinical perspective, we might want to consider outpatient. I would consider outpatient as evaluator and making a recommendation to the court if symptoms are more amenable. So someone with an intellectual disability or a developmental disability really would not benefit from an inpatient psychiatric stay where primarily one is receiving medication for treatment. If a defendant is on bond, if they're already served by the CSB, they likely can continue those wraparound services, and the CSB can provide that competency restoration on an outpatient basis. And often when a mental health docket is involved, I have found that because of mental health dockets, they bring together lots of different disciplines and providers, and because they're planning and speaking and being very mindful and thoughtful about an individual defendant's needs, that's very often a good mechanism to provide outpatient restoration. Inpatient restoration is better for people who are actively psychotic. They may demonstrate symptoms of mania, hypomania. They may be having hallucinations, delusions. Certainly someone who would meet criteria for civil commitment would be appropriate. And if you can't really determine if they're feigning or not. Sanity at the time of the offense in Virginia is another mechanism to get into the hospital. And in Virginia, my understanding is that case law is the mechanism in which our code and our specific legal-related ways in which we evaluate persons provide us that roadmap for us to make our clinical assessment, as opposed to a federal statute in other areas. So not understanding the nature, character, and consequences, unable to distinguish right and wrong, those are the two, quote, cognitive prongs. And then the irresistible impulse prong, the volitional prong, is also something we have in Virginia. Not all states have that. I also want to make a pitch if there are any Commonwealth attorneys in the office, or if anyone would like to be a Commonwealth attorney or a prosecutor. Here in Virginia, we have a second opinion evaluation motion of the Commonwealth, and this is after defense gives notice, and I would say please use it. Often I have seen in my experience an initial evaluation of sanity at the time of the offense can sometimes be a rubber stamp. And there's also been some issues with evaluators not always applying the psycholegal criteria correctly, which could have some implications for preserving the legal system, and certainly might meet the needs of a defense attorney and their client, but maybe not quite the way to go in terms of preserving the legal system and the appropriateness of the spirit of the law, let's say. So in Virginia, we created another law, because that's what we like to do in Virginia. There's quality control of forensic evaluations now. This is very new, so in case folks hadn't heard about it, I wanted to just bring this to your attention. Because forensic reports greatly impact what happens to your defendants and to our clients, our patients, because it can lead to acquittals for persons adjudicated not guilty by reason of insanity, dismissals and null process of cases for persons who are found unrestorable, can delay the process. And I'm moving fast because I'm trying to be mindful of time. I would be respectful of my colleagues. But the goal is to essentially improve evaluators who are writing reports, because in order for us to be in service of the court system, we have to provide you with a good product. If we are not providing you with a good product, then you're struggling to make a decision, and these decisions affect the lives of people. So we are one of the few states that actually have an oversight process in which we as evaluators have to provide a blinded report to a central office, and they in turn are giving us feedback. But they're watching to see if evaluators are essentially meeting the psycholegal criteria. Are they applying it correctly? There's an opportunity for persons to be remediated or mentored through the process. So it's not something in which we want to remove people from their livelihood altogether. But if there is an opportunity for where someone has not been able to continue to grow and improve their skill set, they can no longer provide forensic evaluations in the Commonwealth. And anyone who is working with forensic evaluators, any judges, attorneys, clerks, there is actually and I'm giving you Angela Torres's information in case people want to reach out to her, and I can give you that information more specifically. But there is a spreadsheet with everyone's names, and it is on their website, is on the department's website, DBHDS, which is also at the end of this slide. And if they're on the list, they're good to go. If they're not on the list, you might want to call Dr. Torres. There's probably a reason they're not on the list. Finally, because my colleagues are going to be speaking about behavioral health dockets, I find that they're extremely easy and fun to work with. The staff become experts about competency, and so it's easy to just kind of pick up the phone and talk to each other. Everyone kind of gets it and understands. Having the same staff, so the same Commonwealth attorney, the same public defender, the same judge, the same representative from the CSB, really makes these cases so much easier in which to help these individuals. Returns to jail can be scheduled much more swiftly. I can call the clerk, I can call the judge's assistant and say, Mr. Jones is returning to jail tomorrow. And the judicial assistant can then set a court date within days, ideally to reduce the likelihood of decompensation when they return to jail. And I just really not that I certainly appreciate the adversarial approach is important. I mean, that is the whole reason why we have a judicial system, a legal system. But this is more of a problem-solving approach. It's not adversarial in the way that you all are being taught, and that is much different. And finally, there are lots of things happening in Virginia to try and address the needs of persons with mental illness who are in the criminal justice system. We have crisis intervention teams and police training. Most of the police departments here in Virginia have been trained. We've got numerous assessment sites. They used to be called drop-in centers. They're called CIT assessment centers, where persons are taken to these centers in lieu of jail and provided community-based treatment. We've got numerous mental health dockets just in this region alone. And if I were to make one pitch for a jail diversion, persons who are looking for kind of this arraignment, we need some folks to be working at the level of arraignment, when folks are right in the point when they're getting their charges. We can have CSBs in courts identifying people right away, identifying them for services, and possibly move them out of the system before they get deeper into the system, relating to this something called the sequential intercept model. The deeper you get, the harder it is to extract someone from the criminal justice system. Thank you.
Thank you. Good morning. It is a real pleasure to be with you today. I represent the geographical diversity on this panel, being from the lovely mountains of Southwest Virginia, and it's nice to be here on the at Virginia Beach. This is my first visit to Regent, and I'm quite impressed, not only by the brick and mortar facility, but also by the students. I am looking forward to many of you, or at least some of you, finding your way to the Blue Ridge Mountains and perhaps appearing in front of me in the General District Court. I sit in the 23rd Judicial District, which is a district that encompasses Roanoke City, Roanoke County, and the city of Salem. We have a collective population of about 220,000. It's a nice place to practice law. The bar is very congenial. And I suppose because of the congeniality of the bar and because I'm a native Roanoker, when I returned from graduating from Washington and Lee and started practicing law as a public defender, I began to see the same sorts of people that I had seen as a probation officer. The names were just different, but it was the same sort of malady. And as a new judge, perhaps I'm speaking only for myself, these very learned jurists may have a different experience. I was struggling in the beginning to just figure it out. I've been on the bench now for 22 years. I'm still struggling to figure it out, to make it better, to make it more serviceable, to make it more effective and efficient in doing what we do every day. But I began to see that I was in a fairly unique position to make some changes. And I'm going to tell you the story of how I transitioned from being an ordinary judge to being somebody that really was passionate about a particular topic, not so that you applaud me, but so that to pick up on a topic that Mr. Berry talked with you about. You must be bold and courageous in your practice of law. You must be bold and courageous. If you're not bold and courageous, if you're not thinking critically and thinking creatively, then the system will remain the same, and as Dr. Hudisek said before me, the system is broken. So I began then to look at what I could do to educate myself, to do something to offer some alternative sentencing docket to those individuals that were before the General District Court in particular, who were suffering with a serious mental illness. But before I could get too far along in my quest, judges received a memorandum from then Chief Justice Hassell saying, "You shall create no specialty courts." Well, I don't know where you're from, but that was pretty powerful for me, and especially as a new judge. So I did not question that, but my passion did not dim. I began to wonder, why is this? Why can we not create specialty courts that would deal especially with folks with serious mental illness? Because in my brief study in Roanoke alone, about 28% of the people that were in the local jail were mentally ill. And this was people that were diagnosed. This is not the undiagnosed. This is not the people that go in for 2 days that don't take the survey and are released on bond. These are the people that are waiting in jail for trial, or they've already been tried. So if that is the recorded number, the unrecorded number must be greater. I began to realize that there were financial issues associated with creating a court, a specialty court. You have to have money to staff a docket. You have to have money to provide support personnel for the docket. You have to have time to provide for the docket. Also, timing has to be right. And at that time, we were going through a fiscal shortfall like we've never seen, at least in my lifetime. And money was very, very tight. And to be frank with you, mental health was not then at the top of anyone's list. It just was not. And then there's the philosophy that many members of the General Assembly espouse, which I don't disagree with in theory, that all people should be treated the same. There should be consistency, because consistency promotes fairness. And so when there's fairness in the courtroom, people might not like my decision, but if they believe it to be fair because it's consistent, then they will accept it. They might not like it, but they will accept it. So I still wondered what I could do. I was not content to just let my passion go. And so I began to educate myself. And I began attending conferences. And sometimes in my conferences, I was the only legal person in the conference. The mental health people were talking about barriers and gaps, and I was thinking, Lord, what does all that mean? I don't know. And so I had to, the learning curve was very, very steep. I went to Charlottesville, I went to Richmond, I went to Reno and met up with Judge Doyle as we took a course with the National College there focusing on individuals with co-occurring disorders. And it was at that time that I knew that Judge Doyle had the benefit of Judge Poston's mental health docket in the Norfolk City Circuit Court. And I said, Judge Doyle, how did that happen? He said, I don't know, you'd have to ask Judge Poston. I inherited it when I came on. And so he was scrambling to learn as much as he could about this population. And coming from a prosecutor's point of view, I'm sure the learning curve for him was steep. Maybe not as steep as for me, but it was steep. So after I had educated myself and learned as much as I thought I possibly could, I then decided that it was time for me to draft a written plan and proposal and to start talking with the stakeholders in my community. Because a judge can do a lot of things, but if we don't have personnel to carry it out, it really is just a lot of empty words. So I needed to speak with the local court community corrections who could provide me with supervision. I needed to speak with my community service board director so that they could provide me with the mental health piece. I needed to speak with my Commonwealth's attorneys so they could be in agreement with my vision. I knew it was going to be an easy sell for the defense bar. And you know, as a judge, there's very few perks really, but one of the perks is when you call somebody and you invite them to lunch, they come. And so that's what I did. I called each of the stakeholders to lunch individually, and I said, this is what I'd like to do. And you know, there was not oh, I don't know, we don't have the resources, we don't have this, we don't have, it was, when do you want to start? The Commonwealth's attorneys were very much in favor of it because they see the revolving door of the same people coming in and coming out. The money we're spending on trying these folks, incarcerating these folks, releasing these folks, and then they're back in 2 weeks charged with the same offense, and we're back doing the same thing again. And you have to stop and wonder, and they stop and wonder, what is the benefit here? Is this what the criminal justice system is really supposed to do? So I decided then that I was going to launch a docket, not a court, but a docket, because judges can control dockets, but I can't control and set up a court, but I could control and set up a docket. So that's what I did. And in order to avoid being confused with any mental health court lingo, I called it a therapeutic docket. And it seemed to resonate quite well with the community. I started in July of 2011. I did not notify anyone that I was doing that on the Supreme Court level because I did not want to be told, no, you cannot. You know, sometimes it's better to ask for forgiveness than it is to ask for permission. And so I began. And then I heard Chief Justice Kinzer about 2 years later in her State of the Judiciary speech talk about that she wanted to put together a commission to talk about problem-solving court legislation. And she had already been blindsided by one very powerful delegate who had seen a specialty docket in action and was horrified at its appearance and at the disposition. I respected her greatly, and so I asked if I could have lunch with her because I just wanted to confess, and then I would have to take my punishment, whatever it might be. We met and had lunch at the Martha Washington in Abington. It's a beautiful place. If you get the chance to have lunch there, you should. I drove there. Every pore in my body was sweating. We stood together to have lunch. Of course, I could not eat because my heart was in my throat along with my stomach. And she's a person of very few words. And she said she bit into her sandwich and she's looking at me and I'm trying to make small talk to try to warm up to the subject. And she said, well, what's on your mind? And I thought, well, here goes. And so I told her what I was doing. And at the end of it all, she said, that sounds terrific. Would you like to join the commission? It had its first meeting last week. We're having another meeting in 3 weeks. I want you to join. I'll tell my secretary. Now, how are things going in Roanoke? So that was it. That was the way I became involved with that legislative group. We worked very hard on legislation, but we were unable to get anything passed. And House Bill 96 was dead in 2016. And so Justice Kinzer had retired in 2014, and we then switched to Justice Lemons, who is a visionary. And he has a lot of political awareness, and he is very committed to specialty dockets. And so he enacted, along with the members of his court, a rule, Rule 1:25, and that was in November of 2016. And then in January of 2017, that rule passed, creating specialty dockets. And I thought, oh, great, now I'm legitimate. However, I got a call from him, and he said, I would like for you to be the chair of the Behavioral Health Advisory Committee that vets and examines all applications, because we are going to have a uniform process. There will be no more rogue specialty dockets. And I think, you know, it's the adage of keep your enemies close so that you know what they're doing. So, of course, when the Chief Justice asks you to do something, you don't say, gee, let me think about it. I said, of course, I would be delighted to do that. And so that's a position that I hold today. The specialty dockets, we have 10 of them now. Judge McDonald is here, who the advisory committee has approved his application. I think he will vouch for the fact that the applications are very, very demanding. They are detailed. They are exacting. Judge Doyle and Judge Migliozzi have also filed a application which was approved. And again, it's a very onerous process, but the members that serve with me on the committee represent a very cross-section of both professional and geographical experiences. The committee members consist of Commonwealth's attorneys, public defenders, social workers that have MS degrees. We have a clinical psychologist who teaches at UVA, and Anna Powers, who is the drug court coordinator. She's also the coordinator for amassing the information regarding the specialty dockets. In that Rule 1:25, Judge Lemons also created 2 other specialty dockets, Veterans Docket and the Drug Court Docket. And as many of you may know, the drug court has been ongoing for many years. It was created by statute by the General Assembly, funded by the General Assembly, and it continues to, I think, offer an alternative for folks who have drug addiction issues who find themselves involved with the criminal justice system. My materials are included in your materials. I invite you to look at the materials that you have. I want to update you on the number of people that we have on the therapeutic docket now. I have 35 people in Roanoke County, 20 in Roanoke City, and 13 in Salem. We picked up 5 new people. We've graduated 4 since the data was provided to Sarah. And I want to also say to you that many judges are not comfortable with this alternative sentencing disposition. They're not comfortable with the way that the court unfolds. And that's not to say that's good or bad. It's just a state of fact. They're not comfortable with it. So the judge that takes on this docket is one that has to be able to, in my view, balance what is accountability versus an understanding of the mental illness and the challenges that this person is undergoing with the mental illness that he or she is confronting. I'm happy to talk with anyone about how dockets are examined, how the process. I'm happy to talk with you about my particular docket. As you can tell by my gray hair, I have been around the system for a very long period of time. This is one of the most rewarding things I have ever done. To see someone's life in complete darkness, complete confusion, complete inability to just cope with the normal day-to-day things of getting up, getting dressed, getting out the door. And then to see people transform into smiles, life is good, I'm on my medication, thank you for caring, thank you for taking an interest in me. I don't tell you this so that, again, that you think I'm terrific. I think I'm almost ready to retire, almost, not quite yet. I think, have some good left in me. But you are going to take over the system when people like me step away. And I hope that you will see that the criminal justice system doesn't have to be the way it has traditionally been. It can be an area where you can make a difference for your clients, for your neighbors, and now with the opioid addiction issue just raging, you know that people that come before the criminal justice system are not all bad people. They're not all evil people. They just made some bad decisions along the way, or they have an addiction that they cannot control. So I urge you to be creative, to be bold, to be positive in your thinking, and to make a difference when you practice law. And I'd love to talk with you afterwards if you have any questions for me. Thank you so much.
This is Judge Migliozzi's PowerPoint, but he's elbowing me to go first. I think that's so that he goes last and he only has 1 minute left to talk, and he doesn't really have to do much. Right.
Save the best for last.
We both sit in the Norfolk Circuit Court. Judge Talevi referred to it. When I was a Commonwealth's attorney, I'm really not sure what year it was, 2002, 2003, 2004, Judge Poston called me and had this idea. It was his own little idea at the time. And the idea was that we need to do something more robust in how we would deal with defendants charged with felonies who really were not going to be not guilty by reason of insanity. They didn't have that sort of an issue going on. They weren't even incompetent. They were competent. But clearly mental illness was a big factor in their continuing criminal behavior and arrest and coming before the court, and the frustration of seeing these people over and over without really having a plan of how to deal with this criminal illness factor. So Judge Poston's idea was just to come up with something more robust. And the idea that he came up with essentially was a intensive supervision type approach, is what it is, with a team approach. And so I'm going to explain to you how that idea has grown over the years. And I was the Commonwealth's attorney at the time, and I fully agreed with him, and we signed on. The Sheriff's Department signed on, Probation and Parole signed on, and the Community Services Board signed on. Now the point of all that is this program did not cost a penny. All we had to do was get everybody together, it was already in place, agree we would do it, and it just started happening. But we didn't have to get a grant. Later we did need some money for drug testing, things like that, but it didn't cost a penny. Everything was in place in order to do it right away. Now, as I say, this is the population that we're targeting. People charged with felonies, but competent and not insane at the time of the offense, clearly. Now, the first step was screening. And what we have now is we have a team that screens people for the mental health docket. The defendant pleads guilty straight up as charged, and sentencing then is delayed. So the program occurs between the guilty plea and the guilty finding and the eventual sentencing. This is the period of time with which the program is working with this person. So it truly is a docket. When someone is accepted into the program, their case just gets assigned for sentencing to the mental health docket judge, and the case is put on the mental health, that defendant is on the mental health docket. The carrot at the end of the stick is if they graduate the program, then we give them a completely suspended sentence without any more supervision. That's sort of the carrot at the end of the stick. If they don't complete the program, if they're violated out, then they just proceed to be sentenced. So the first step of the program is screening. The screening is a team approach, and the screening does involve the approval of the Commonwealth's attorney. The way this worked in the beginning was the Commonwealth's attorney basically had, you could call it veto power over anybody getting into the program. In a way, that was what was necessary to get the program up and running. But also the positive thing about that is we don't have a whole lot of absolute disqualifiers. If you're convicted of a violent crime, you can't get in. We don't have that, and the reason we don't have that is a lot of times it might be the person's assaulted a police officer, which is a felony with a mandatory 6-month minimum sentence. But the police officer recognizes that this was a mentally ill person they're dealing with, and the prosecutor recognized that as well, and then eventually we have a way of getting that person in the program, because we don't have these we have some, but not many black and white. If you're convicted of this, you can't get in type approach. Now, in the screening, we're not looking for the low-hanging fruit, so to speak. At the program in Reno, the training in Reno, Judge Levy and I went to, they taught us this. If you think of a spectrum, defendants fall into one of 8 categories. Category 1 would be low criminogenic risk, no substance abuse, no mental health issue. All right. Category 2 would be the same thing, but maybe some minor mental illness. And then there's a continuum. And so we're looking for the 6s and 8s, I would tell the team all the time. We're looking for the people that have either severe mental illness, severe substance abuse, and high criminogenic risk, or those are the 8s, or we're looking for the 6s, which would be just sort of moderate of all those. Now, you could fill your program up, we tell the team, we can fill our program up with the 2s and the 4s. And guess what? They'll all graduate, and we'll feel great, and we'll pat ourselves on the back about what a wonderful program we have. But it's not necessary. Regular probation can deal with those people. So we're looking for the 6s and 8s. Now, sometimes we can only get those 6s and 8s. It's difficult to get them in the program, because if you have someone that falls in the 6 or an 8 category, they have high criminogenic risk, high substance abuse, high mental illness. If they commit a rash of residential burglaries, they're not going to get into the mental health docket program. It's just not going to happen. The prosecutor's not going to agree to it. The victims aren't going to agree to it. It just can't be done. But where we get those 6s and 8s are through probation violations. So a 6 or an 8 does residential burglaries. They get put on probation, and they know new crimes, but maybe they miss some appointments. They test positive a few times. Probation officer initiates a probation violation proceeding, and that's our opportunity to get those people into the mental health docket. Once they're in, it's a phased approach, and it's overseen by a team. The team is the Community Services Board, as I mentioned, Probation and Parole, an assistant Commonwealth attorney, and the judge, and also the sheriff. The jail is involved, and that's important also. And we try to have consistency. So probation parole assigns a probation officer as the team member. CSB assigns a case manager. The judge is the same. It was me for 4 years after Judge Poston retired. I turned it over to Judge Migliozzi last January because he kept bugging me. He wanted to do this, and so now he's doing it. Everything else I'm going to tell you now, and I'm going very quickly to give Judge Migliozzi his minute to talk, is what we learned in Reno at the National Judicial College. I took this over from Judge Poston, and the first 6 months I'm doing it. I'm like, we don't really have a game plan. I don't really know what I'm trying to do here. I'm just, if they're doing good, I'm a cheerleader, and if they're doing bad, I'm the bad cop. This is not really working. So I jumped on the opportunity to go to the co-occurring disorder training in Reno National Judicial College. I walked in, and there was Judge Levy, who I already knew, and I was so happy to see her there. There were about 15 judges from all over the country there, and I was proud of the fact that 2 of us were from Virginia. And the facilitating judges from Albany, Georgia, the probation officers on the faculty was from Idaho, maybe Boise, I'm not sure, Jackie, we're in Idaho. We had judges from Massachusetts, Pennsylvania, but there were 2 of us from Virginia. Everything else I'm going to tell you is what they taught us, and I completely bought into it. It's an evidence-based approach in what we're trying to accomplish with these people. An evidence-based approach just means that research shows that there are risk factors in predicting criminal behavior. Some of those risk factors are static. You can't change them. They're in history. It might be how old were you the first time you got arrested, things like that. Can't do anything about it. But then there are dynamic risk factors that you can change. And so what we focus on is trying to just checklist, eliminate as many dynamic risk factors as we can for each participant. What are these? Housing, homelessness, housing, a home of their own they can be proud of, job, employment. It might be idleness. That's a big challenge with a lot of our population. A lot of the participants are on disability and they're just idle, and we have to find a way to get them busy and occupied. But all these risk factors, and if you can eliminate each one, then according to the research, the risk of recidivism should be going down. And so that's the approach. Now the first 2 main risk factors, of course, are substance abuse and getting them connected with their mental health providers. And so that's the main focus in phase 1, is testing them, sanctioning them. We do use short stays in jail if necessary as a sanction. We have other sanctions as well to try to get them in touch with their physician and as best we can get them sober and off of drugs. And as I tell them, I said, look, if your psychiatrist prescribes cocaine as something that will help you feel better, then we'll talk about it, but I don't think your doctor is prescribing cocaine or heroin or whatever else or alcohol as a drug that's going to help you deal with your mental illness, which is not your fault, but it's a reality in your life, you have to deal with it. Now the thing that surprised me, and they taught us about this in Reno, and then as I got into the program and started doing it, we could be quite successful in eliminating a lot of risk factors. We can be successful this is what I've learned about dealing with this population. We can be successful in getting them on their medications and in touch with their psychiatrist. We can be successful in getting them sober and off drugs and alcohol. But a lot of times when we reach that point, our work is just beginning. Because these people have developed all these, Dr. Hudchek probably tell them what the name of this is, but they've developed all these tangential behaviors, negative behaviors that are completely interfering with their ability to be successful and happy in life, and resulting in drama and a lot of problems and arrests over and over. And these behaviors, no doubt, I think, are developed because they have lived their life as a mentally ill person dealing with mental illness, but then they've developed these other behaviors which can be very difficult to change and get them out of. Some of the behaviors I've seen in the past are just stubbornness, just impulsiveness. I mean, some of these folks that come in front of you, they were so good at getting in trouble, and then I would call it, they have a bag of tricks. They would cry, they would use logic, they would stamp their feet, they would get mad, they would have excuses, they would blame you, they would blame whoever, and they would just pull these bags of tricks out to try to get them out of whatever problem they had developed. And so a lot of our time, especially in the later phases, is trying to get them to recognize those behavior patterns and trying to get them to be willing to accept that that is something that's happening and that it is something they need to change if they want to be successful. We don't have we don't have as high a graduation rate as the drug court, but I'm convinced that even people that go through the program and eventually get violated out have still received a tremendous benefit being in the program, because even if they've flunked out, so to speak, probably by that point we've checked a few dynamic risk factors off the board, and which should help them be more successful in life. I'll turn over to my colleague.
Please excuse me for my voice. I'm still recovering from the Red Sox victory party. Go Sox. All right. Go Sox. All right. Anyway. Oops. All right. Sorry. Well, to address the slideshow presentation, that's the United States up there, by the way. Judge Doyle and I labored intensively over the past week, preparing for this and preparing this, for CLE stuff. We put every slide of this together, and we worked really hard at it. And as you're going to find out in the next 10, 15 minutes, most of what I say is not true. So that's not true. I would like to recognize Heather Wong, who is back. Heather, will you stand up, please? Heather is a 3L here at Regent, and she prepared this entire 90-page slideshow. That's the entire thing, and she did it in 5 days. You can see she did it in 5 days in preparation for my trip to London a couple weeks ago, and so the slideshow is got a lot of statistics in it, and they're very important. Virginia statistics and national statistics, and Dr. Hudasek went over a lot of those statistics, and so I'm not going to go over those right now. But what I want to say, and this was brought up by some of the other speakers here, especially Judge Talevi, I developed the same interest, Judge Talevi, as you did in this early on. First of all, I'm a Regent alum, class of '94, and I've met a few of you here, the law review editor, and I just got to say, class of '94 is way better than this card class. But anyway, but between my second and third year, I interned, as was said earlier, at the St. Elizabeth Hospital in D.C., which is a public defender's unit. It's the public defender's unit at St. Elizabeth Hospital. They have an office there, and that's where I interned, at that office. And that was the same facility where they were keeping Hinckley, who I met while he was there with his lawyer, who was also a public defender. And so it was really interesting, and it just sort of, it created some, pre-practicing interest in my mind. And then, as I started practicing as a public defender and in private practice, I recognized the issue that was going on. And then when I took the bench in 2009, April 2009, coming up on 10 years, I started in General District Court. And Judge Talevi, you can recognize this. I would have people coming in with clients, lawyers coming in with clients. I'd appoint them, and they'd say, Judge, I went back and met with him, and there's a competency issue here, I believe. I'd like to request a competency evaluation. Well, we would appoint an expert from the list that we had in the courtroom for a competency evaluation, and we would continue it out 30 days. Well, I would say 60% of the time, we would come back in 60 days, and this defendant was usually as a trespassing or indecent exposure, some class 1 misdemeanor. He's being held in custody. We'd come back in 30 days, and the evaluation wasn't finished yet. 30 days. So I would have to continue it another 30 days to get that evaluation. Now we're talking 60 days. And if he came back not competent, then what's the next step? Restoration. So we would refer them to Eastern State, doctor, no offense, but we would refer them to Eastern State, and the average turnaround time to get the person from the Norfolk General District Court into Eastern State Hospital for restoration was 180 days. That's 6 months. If I did my math correct, is that correct? All right, thanks. That's 6 months, plus the 2 months he was already in being evaluated. So, and that's just to get in the front door for restoration purposes. So, after about 6 months of that happening, I got frustrated. I mean, I literally got frustrated. It was just not just. So I got together with the chief judge at the time, and he said, "Do what you want," and the head clerk and the sheriff at the time, and we decided to form a mental health court in General District Court, and this was in the January of 2010. So we were sort of advised at the time the first thing to do would be to put together a outline of what your program is, the procedures, and put together an outline. So we put together about a 5-page outline over about a month's time, and Judge Sleeve, you'll appreciate this, we submitted it to OES, and they said, "Judge, take this outline, throw it in the trash, and go to the rule book and see that you can create a docket however you want. But don't create a specialty court." Because that was at the same time that we had the ruling from the Chief Justice at the time that, specialty courts were only permissible if the General Assembly ruled on them, if the General Assembly passed a bill saying that you can have a specialty court. Otherwise, you couldn't have one. So, and then the rules specifically say that you can you can create a docket. Some jurisdictions up in Fairfax, they have a DUI docket, 1 day a week, all day in the afternoon. And so I said, all right, all people who are have competency issues or competency evaluations, we're going to put them on a docket every other Wednesday in General District Court. And so that's how we started it. And it's so I appreciate what Judge Levy said. And even to this day, I will tell you that despite what Judge Doyle and I do in circuit court with felonies, it is critical that these courts exist in General District, because as Judge Levy said, most of these people being picked up they live outside. They live alongside train tracks or under bridges or someplace, and a lot of them are getting up and being charged with trespassing around train tracks, or they're urinating someplace and they're getting charged with indecent exposure, these class 1 misdemeanors, and they're coming in, and most of them I've found have never been diagnosed before. Never been diagnosed. Some may have early on. They just, they got out of the military. They were diagnosed with PTSD, and the Veterans Administration said, here, and they can't get to the VA. They just don't have the transportation. They don't have the willpower to get all the way over to the VA and renew their prescriptions. And so, they're self-medicating, which is what the co-occurring issue is. They're self-medicating with, opioids or heroin or whatever. And so it was a crazy problem. We're seeing all these misdemeanors come in. And then, as you all know, at least here in Virginia, all the felonies, at least by warrant anyway, are arraigned in General District Court. And they have the preliminary hearing that starts down there. And so the General District Court judges in Virginia see for the first time, all of these persons that are potentially affected by mental illness. And that's why I believe that it is critical, and I hope the commission maybe takes this up sometime, that there should be a general questionnaire, like 3 questions that a general district court judge always asks someone on arraignment that may identify mental health issues. It just seems like common sense. Let's see. The other thing, I was just talking about my past, the other thing that, in terms of credentials and my respect for this issue is, not only did I meet Mr. Hinckley, but as soon as I was appointed as the capital defender for this area, I got assigned the Darrell Atkins case. And we had handled that case. And Darrell Atkins, as you know, changed the law in the country with regard to execution of persons that are mentally retarded. Now, different term, but and so I worked for 3 years on that case, actually 4 years, and I couldn't believe what I learned with regard to mental health issues, and so that is probably why when I got up to circuit court, finally I was bugging Judge Doyle. I said, "Come on, I need to help. I need to help, or at least participate in it." And so I find that it is a very important issue. I've learned recently that Miami in Arizona, and I forget what specific area in Arizona, and it may just be the entire state, but the Miami County, city of Miami, they have developed these lower court systems which don't even charge a person with a misdemeanor coming in. So if a person gets picked up with trespassing or picked up with, for indecent exposure, so one of these things, they're not even charged. They're identified, first of all, as having a mental illness, and they're immediately diverted to a holding facility that does nothing but counsel and do what we do in the circuit court. Identify risk factors and eliminate those risk factors, get them on a plan with meeting with a mental health caretaker, provider, and get their prescription medications in order. And in order to be released from that facility, they have to show that they, respect it and that they're adhering to that plan. And then they're placed on probation or some type of probation. But there's not even a charge. And we had the good fortune at our last judicial conference in Roanoke to hear from a judge that started that program down in Miami. And it's just a really interesting thing. But I'm going to finish off by saying this, and I strongly recommend everyone to look at this outline, this slideshow that Heather put together, because it's the statistics in there are just overwhelming. And the first part of the outline is, I'll just say this. Oh, oops, I think I was going the wrong way, sorry. Major depressive episodes. MDEs, major depressive episodes. Depression is a form of mental illness. The very first panel, I was interested by the topic of this first panel that we had today because they were talking about these issues as they affect law students. Well, law students can get depressed when they don't do well their first year, things of that nature. You know that, Will. Right? So anyway, it's so yeah, major depression, and then of course, couple that with major depression with people that already have severe mental illnesses. So anyway, one of the things, one of the best experiences I had with Judge Doyle was when he was a Commonwealth attorney and I was a capital defender, and we had a capital case together. And I mean, we were adversaries, but I've never seen a person handle his position so professionally. Close your ears for a minute. Just close your ears. I mean, the professionalism was amazing, and I just developed so much respect for him at that time. But when I was a capital defender, and I left that, to get on the bench, but I've been lecturing about the death penalty for the past 10 years over in London, and starting last year, I started doing a lecture for half a day on mental illness in the correctional system. And I did it this year. And I'm ending with this. And I did it this year, and I didn't realize, I know it's an epidemic here. It really is. Not just in the criminal justice system, but nationwide in our national health. And but it is even more critical there in their society. They have what they call the National Health System, NHS. So anyway, I was giving this presentation, got a lot of questions, and afterwards the dean brought up this lady to me, and her name was Dr. Ryan. And I told this when we were having dinner last night, but I'm bringing it up today for a special reason, because I just learned something literally this morning about this issue. So Dr. Ryan was introduced to me. She was a PhD. She got her PhD at Warwick, and she's now a professor at Oxford. And she teaches on mental health and issues involving mental health in the National Health System in the UK. And when she got her PhD, she worked with the National Health System dealing with mental illness and stuff like that. And then she went on to become a professor at Oxford. Well, she also was happily married with 5 children. And her second youngest child, who was a son, was born with a major health issue, psychosis. And so as a young child, they treated it, and they brought him in for psychotherapy and whatnot, and they treated it with medication. Then when he got to be a teenager, and reached the age of puberty and all that kind of stuff, it just sort of, it escalated. And it got to a point where the son was creating sort of a dangerous environment for the other siblings in the household, as well as the neighbors in their neighborhood. And so with great sadness and great despair, they put their son in the National Health System basically they still have what they call, what we used to call asylums here. But they put him in one of these health hospitals, mental health hospitals. Well, within a month and a half, he died. And he died as a result of the services that weren't provided in that health system. And she went crazy and just advocated against what they did and what they didn't do, and had that hospital shut down. And then she wrote a book, and her picture of her son is on the front page, on the front cover of this book. It just to look at it just makes you sad. But anyway, and the book is called How to Make a Boy Laugh. And Anyway, so she gave me a copy of the book, and I started reading it, and it's overwhelming. It's heavy on the heart. But what I learned this morning is that coming out today from Hollywood at the movie theaters is a movie called A Good Boy, and it's based on this story. And it's about and the father in this movie is the guy who is the head of the, what's his name? Steve Carell. Yeah. Anyway, he's the father. So it's a big Hollywood production, but this kid had a mental health issue, and he was dealing with it with marijuana, and then advanced to other higher types of drugs. And then sort of know how that ends. But it was just, I just learned about this. I was seeing the previews, and then I finally, because they're 5 hours ahead of us, I finally texted, "Does this have anything to do with you?" Yes. And so I was amazed by that, and I'm sorry if it has nothing to do with this, but I had to bring it up. But it was just amazing. So thank you very much for the opportunity to speak here today. Oh, one last thing I have to mention, and it's a matter of pride. Norfolk has four. I'm sorry if I'm doing. Has 4 specialty courts. We have all 4. We have, I think, the oldest drug court. We're about to celebrate next week our 20th anniversary of the Norfolk Drug Court, presided over by the same judge since it started. We also have the Mental Health Court, which was started by Judge Poston in early 2000s. And then we also have a reentry court, helping people get back into society after, all these felony convictions and things of that nature. And then we also have a veterans track court, which is obviously appropriate for this area. So I take a great deal of pride in working with these people that handle that stuff. So thank you very much.